And welcome back to the Morning Docket here at Long Crime, everybody. I'm Jesse Weber, and thanks for joining us. What a morning we are having right now in the trial of Darrell Brooks, the man facing a slew of charges in connection with allegedly driving his red SUV into a group of holiday parade goers in Waukesha, Wisconsin, back in November of 2021, killing 6 people, injuring dozens of others. He has decided to represent himself. Anybody who's been following this case know that there has been fireworks. There's been fireworks between the judge and Brooks, who just seemingly keeps putting forward these strange and nonsensical legal arguments. And the tone he has taken with the court has been bad, but nothing like we saw today, where he basically was screaming at the judge. And I want to talk about this right now with litigator Richard Schoenstein, who's watching this with me in real time. I've never seen anything like this, Rich. I've never seen such disrespect to the court. Screaming at her that this is my life, you're not on trial, I'm not, you think I'm not taking this seriously. I'm just going to ask your reaction to that.
Jesse, I've never seen anything like it either. And I think about it this way, I've been litigating cases for a long time. I've been before hundreds of judges all over the country. I've never had a judge been as nice to me as this judge is being to Brooks, and as patient and trying as hard as she is to let him mount a defense. She is bending over backwards. I've had judges yell at me when I wanted 5 extra pages in a brief. If I tried to make leading objections during someone's cross-examination, most judges would throw me out of the courtroom. It's amazing what she's doing, and he is just continually self-destructing and melting down. It was such a bad idea for him to represent himself, and the way he's doing it is just terrible.
Let's get into this million-dollar question here, because I keep getting asked it, and I want to hear your perspective. The question is, how come she hasn't kicked him out of the courtroom? And here's my take on it. My take is, I think we can all agree this is about to go to a conviction. The evidence against him is overwhelming that he did this. If she created a situation where she kept shutting him up, kept, kicking him out of the courtroom, wasn't really respecting any of his objections, an appellate court could look at this and say he was treated unfairly and that conviction should be overturned. I think she is going out of her way to give him every benefit of the doubt, so much leeway, more patience than I've seen any other judge, because when he is convicted, there's really nothing. He's going to obviously make arguments, but there's really nothing legally he can hold his hat on, because she has done everything to give him the benefit. And if anyone's burying him, it's himself. Am I off?
You're not. You, my friend, are 100% right. She is laser focused. She is protecting this trial. She wants to get this trial to the jury. She wants to get a jury verdict, and she wants to make sure there is no chance on God's green earth that that jury verdict is overturned on appeal. So she is giving him as much leeway as she possibly can. She's explaining, she's citing statutes when she overrules his objection. Judges don't do that. They just say overruled and tell you to move to the next question. They don't, they don't get into these legal debates, but she's doing it. She is very carefully making a record here, a record that I think is going to stand up on appeal. Absolutely.
Let's go to the opening yesterday. Let's go to the defense's opening, because Rich, I was following your Twitter account about this, and you had an interesting take. Let's watch a little bit of Darrell Brooks presenting his opening statement.
The power that you have.
Okay, so first of all, let me just be clear about why this breakdown happened. Yesterday, there was a request of Brooks by the court. You have to give us the order of your witnesses. Who are you going to call, when? And he just wouldn't do it. Remember, he's been kind of non-compliant throughout the course of this, and he wouldn't do it. So the court had to step in and said, okay, we're going to put forward your order of witnesses. And the third witness to be called this morning was supposed to be Erica Patterson, the defendant's ex-girlfriend. He took an objection to that. There were going to be more witnesses that were scheduled later on in the afternoon. He did not want her called right then and there. This is how the breakdown ultimately happened. We're going to see how it gets resolved when court starts up again. But Rich, just going to the opening statement, I follow you on Twitter. You could correct me if I'm wrong. You felt this had an impact, him getting emotional.
I thought his opening statement was easily his finest moment in this trial. He stood up, he took his mask off for the first time, which I thought was very effective. He was calm. There was no nonsense. He didn't get into any of his mania. He was emotional. He seemed perhaps remorseful. And he said to the jury, you haven't heard the other side of the story yet. Nobody's heard the other side of the story yet. And Jesse, it got me interested. Okay, I want to hear the other side of the story. And by the way, it was also very short and to the point. In that regard, it could be a lesson for some defense lawyers out there who go on and on and on in their opening statement. I thought it was really effective. The problem is when it was over, he stood up when court resumed and said, I would like to call the state of Wisconsin as my first witness. And
well, he is who he is.
All the air out.
You know, that's the thing. Look, I hear you. I get it. I think the fact that he wasn't wearing a mask because I thought it was for COVID, but now it seems like it was for some other reason, and maybe goes a little bit in my mind to the deception of it. But anyway, let's go a little bit more to some more of this opening, and we'll break it down.